needs of our citizens at that time. Times have changed. Today it would be easier for the justices, judges, and the staff of the unified judicial system to simply sit in their courthouses, decide disputes, and send the litigants on their way with a decision. The role of the judiciary in modern society, however, demands more than ivory tower justice. For the past several years, I've spoken to this legislature about those factors which have required the UJS to become more proactive in how it accomplishes its constitutional and statutory tasks. This year, it's my proposal to delineate and discuss in a more organized manner all the major factors that face the UJS. The first factor, and in my opinion the most important, is the disintegration of what we knew to be the family back in 1975. I'm not alone in this view. A few years ago, when all the judges of this state were polled, they unanimously chose disintegration of the family as the #1 factor which has affected the environment in which the UJS does its work. In 1975, most juveniles came into court with 2 parents. Now, it's not uncommon for juveniles to come into court simply without parents, because none can be located. In these situations, problems will not be solved at home, and parental discipline will not be applied because there are no parents. This requires the UJS, through its various probation programs, to attempt to correct the juveniles' mistakes and return them to the right path before they become another statistic in a state finance institution. There are obvious reasons for doing so. From a human standpoint, this saves juveniles from wasting their lives. It is also a matter of simple economics. It is cheaper to use probation services than place a juvenile in a state financed institution. It is also cheaper to end the trips to the courthouse at the first outing before they become an endless merry-go-round. There are all too many instances which demand institutionalization, but for lesser offenses, non-institutional supervision by court services is often the better alternative. Where to draw the line? That's the tough question the trial judge must answer. The second factor facing the UJS is an alarming increase in domestic violence. Each year when I give this message to you, without fail, I report yet another rise in the incidence of domestic violence. I have no way of knowing whether all of this is a real increase or whether the numbers are influenced by the fact that it is now socially acceptable for victims to report domestic violence. Victims no longer hang their heads and hide their injuries in silent humiliation. While we have not succeeded in eradicating domestic violence, we do educate the public that these acts are criminal acts. We must once and for all end the sorry state that a victim is victimized twice, once by the perpetrator and a second time by an indifferent judicial system. In 1975, the only recourse for a victim of domestic violence was divorce or criminal prosecution for assault. No matter how brutal the act, the law did not allow for the prosecution of rape if the attacker and the victim happened to be married. Now, the legislature has enacted laws which allow the court to more promptly intervene and protect victims of domestic violence, as well as members of the victim's family. I talk to judges who have an entire day's docket of nothing other than one case of domestic abuse after another. While personalities play an obvious role, so do other underlying causes, such as mental illness, substance abuse, and poverty. Often, to end the repeated trips to the courthouse, judges must become more proactive and order counseling for the perpetrator and help other members of the family. A third factor that's vastly changed South Dakota is drug abuse. This is the 21st century version of the biblical disease of leprosy. When I was a trial judge from 1986 to 1995, virtually every felon I saw in my court was due to alcohol abuse. Now in 2009, circuit judges are telling me that 75% of the felony caseload in places such as Rapid City and Sioux Falls are drug-related. This is not just 75% of drug felonies, this is 75% of all felonies. People either commit felonies to get high or are high when they commit the felonies. It may be too simplistic to say that if we solve the drug problem and the alcohol problem in South Dakota, we have also solved the crime problem. However, those who commit a felony in this state as an intelligent choice, free from the influences of alcohol and drugs, are few and far between. Wouldn't it be a pleasant problem for this legislature to have to decide what to do with empty prisons because they are no longer needed for their original purpose? For the past several years, I have advocated the use of drug courts and other treatment programs to solve underlying problems which cause nonviolent people to commit crimes, rather than just to lock them up, to let them out, to lock them up again and again for yet another crime, which seems to be a revolving door. Incarcerating people addicted to methamphetamine without treating them is as successful at eliminating that addiction as treating cancer by incarceration. A successful treatment program gives those addicts who have committed a criminal offense the tools to rid themselves of that addiction. They can then become useful citizens in society who hold jobs, raise their families properly, and are taxpayers rather than government expenses. Last spring, I received a report from our Northern Hills Drug Court on one 23-year-old convicted felon who, but for that program, would be in the penitentiary. That report stated, one participant was accepted into college, and she begins March 5th. We are very proud of her. She's kind of scared, though, because she has not gone to school sober since junior high. We give her all the encouragement we can. That drug felon has now completed her first year of college with an impressive GPA of 3.85. Instead of looking forward to a parole board hearing, she may be looking forward to graduating from college by mid-cap. The child of another drug court participant commented that it was nice to see her mother be a mom for the first time. Lest you think this is a program limited to young women, another enrollee is a 38-year-old farmer who is the father of 6. Instead of being in the penitentiary, he is home, farming. His kids are with him and not in the custody and at the expense of the Department of Social Services. Alcohol treatment programs have been around for a long time. We know which types of alcohol treatment programs work and which do not. In comparison, we're in the infancy of drug treatment programs. Drugs which are manufactured in illegal drug labs are a new curse. I doubt when the UJS was created in 1975 that meth even existed as a street drug. A successful treatment program seeks to avoid a second generation of people troubled with disabilities by seeing to it that mothers give birth to healthy babies rather than meth babies. Meth babies are born with birth defects, which in all too many cases are significant and permanent. They may be in need of governmental assistance for the rest of their lives. These meth babies, when they grow into adulthood, what kind of parenting skills will they possess? At this point, I can make a strong distinction between drug addicts and drug dealers. Since 1975, the number of people in South Dakota who are willing to exploit the weaknesses of others for profit by selling addictive drugs has exploded. This legislature has seen fit to authorize significant criminal sentences for drug dealers. Their treatment in the judicial system is an entirely different matter than the reformation of those individuals whom the dealers have lured into addiction, all for the sake of making a profit. 3 years ago, I proposed the concept of the drug court. I told you I thought it would work. During the past 2 years when the drug court became operational, I told you it appeared to be working. Now, with 4 successful graduations and the continuing success of our other participants, today I'm pleased to simply say it works. How well does it work? Well, there have been, of course, humanitarian gains, but in terms of cold hard cash, the National Institute on Drug Abuse has determined that for every dollar invested in drug treatment programs, that will result in savings of $12 in crime and health care costs. The disintegration of the family, the increase in domestic violence, the alarming increase in drug abuse give rise to poverty, which is the 4th factor facing the UJS. It is obvious that poverty existed in 1975 and well before, but perhaps now it is more visible, or at least we're aware of it. Who in 1975 in South Dakota heard a vocabulary which included terms like dumpster divers? While other agencies in the state deal directly with job services, the UJS all too often finds it necessary to break the cycle of poverty court service officers, in addition to the regular caseload, must attempt to get the person a job or job training where necessary. At this point, you might think the portions of my message concerning the increasing problems of society and the family's dysfunction are dreary at best, and that you long for the good old days of 1975. Obviously, we cannot turn back the clock. However, I am convinced that without proactive participation by the UJS to solve these problems, things would be a whole lot worse. The fifth factor we face is the changing population dynamics. While many counties retain a relatively stable population base or experience some decline, we have counties which have undergone what could be described as a population explosion. I have yet to hear a serious argument that expansion and growth for South Dakota is undesirable. It is necessary to avoid outmigration of our citizens, especially those whom we have recently educated at taxpayer expense and are our future. Yet an increase in population brings with it an increase in demands upon the court system. A recent example is the city of Aberdeen, where 3 major industries may enjoy up to 1,300 new jobs. While we would like to think all will go splendidly for Aberdeen, history teaches us that that will not always be the case. Because of this population expansion, in future years with probable increases in court caseloads, it may become necessary to seek an additional court service officer. Along with the shift in overall population, the availability of attorneys within South Dakota has changed. 35% of all licensed attorneys in South Dakota now reside in one county, Minnehaha. To put it another way, 2/3 of all attorneys in South Dakota are now found in just 3 counties, Minnehaha, Pennington, and Hughes. On the other hand, we now have 2 counties in the state with no attorneys. 14 counties have 1 licensed attorney. 7 counties have only 2 licensed attorneys. Worse, many of these rural attorneys are approaching retirement, and unless something is done, the likelihood of replacing these attorneys is remote. The Chief Justice and the presiding circuit judges have authority to assign judges to cover every county in the state. This we do. Without attorneys available, however, the issue of whether the courthouse door is locked or open and a judge present really doesn't matter much. The real and sad truth is that we are heading, as a state, to a system that will not provide justice for all, no matter the location. We are instead heading for a state which contains islands of justice in a sea of empty rural courthouses. A 6th factor now affecting the UJS is how it does its business, in other words, technology. In 1975, the height of technology was probably an IBM selected typewriter. Pencils and paper accomplished most office tasks, and to compute meant to add a column of figures with a manual adding machine. For many years, the UJS has taken advantage of advancements in technology. This has allowed us to do more work with fewer employees than would have been otherwise required. It has also allowed us to keep rural courthouses open while dealing with the ever-increasing caseloads in urban areas. It has made our system more unified in operation as well as in name. Technology has not been limited to just support tasks. We are engaged in an ongoing program of video conferencing, which allows hearings to be held with the judge, attorneys, and parties participating from various locations throughout the state. And it's an excellent way to save on windshield time and taxpayer expense. This is especially beneficial to rural courthouses that do not have a resident circuit judge on site. Even better, it's blizzard-proof. In many ways, the use of technology in the court system is only limited by our imagination. I recently received the following letter from one of our circuit judges. He said, "I thought you might be interested in another use for the interactive television network. I had an arraignment, plea, and sentencing hearing yesterday in Bison. The defendant is deaf and communicates through sign language. There are no deaf interpreters in Perkins County or anywhere that we could find. We employed one from Rapid City that we had previously used in Belle Fourche. Rather than having her drive all the way to Bison, she appeared on ITV from the Pennington County Courthouse. I was in Bison with the defendant and positioned her and myself so that we could both see the interpreter. The interpreter could see the defendant through the monitor. The judge concluded it worked very well." Changes in technology are ongoing. Experts say the court systems are heading to the point where they will become totally paperless. A few jurisdictions have almost met this goal. Because the UJS is a court system of general jurisdiction, meaning we take all types of cases brought before us, a goal of being paperless as a court system is a ways off. In 1975, the issue of cameras in the trial courts was basically a technology issue. Most broadcasting needed to be done in television studios. Courtrooms were not television studios, and the two did not mix. With advances in technology, the issue is no longer whether cameras can function in a courtroom, but to what extent, if any, cameras are appropriate in a courtroom. Last year, this legislature repealed its prohibition on cameras in the trial courts in the state. Supreme Court rules, however, continue to prohibit the practice. The Supreme Court created a committee to research the subject. All groups that are components of the judicial process and the media are represented on this committee. It is now looking at how other jurisdictions are dealing with this issue and will make recommendations to the Supreme Court. Because there are 49 other states, numerous territories, and a federal court system, the committee has a major undertaking to review what is being done elsewhere. The Supreme Court is interested in a thorough report, not a quick one. Upon receipt of that report, the Supreme Court will consider whether to modify the current system. The UJS has dedicated judges and support staff who are committed to overcoming these modern-day problems I've talked about. Judging is a demanding profession. To paraphrase President Reagan, on a good day, anyone can be a judge, but there are not that many good days. In reality, there are more challenges than problems, and this state was built on overcoming challenges of all sorts. Had we not, as a state, identified and successfully overcome these challenges, today the norm would be as it was in 1889, Dakota Territory with individual hopes for 160 acres and a mule. Later, the greatest generation overcame the Depression, Dust Bowls, and World War II. Today, our Dust Bowls and our Hitlers come out of the meth lab, poverty, and the disintegration of the family. We have identified these challenges. We are attempting to solve them. Therefore, in the words of the leader of the greatest generation, the only thing we have to fear is fear itself. This legislature has a responsibility of funding the operation of the three branches of state government. Anytime a new program is proposed, no matter how meritorious it is, it comes with the prospect that it may become yet another fixture on the landscape of our government with permanent funding requirements. As a specific example, will that apply to our drug treatment programs? I have no crystal ball to give you an accurate estimate. There is a possibility that drug addiction will be overcome through public education and other methods which will make the drug programs unnecessary since we don't have the addicts to treat. However, that does not appear likely in the foreseeable future. Another prospect, perhaps more likely, is advances in medical science. I have heard of proposals that one-day drug addiction will be successfully treated with a pill, the same way we treat high blood pressure and high cholesterol today. Since 1975, UJS would have remained nothing more than a paper document, except for the dedication of its judges and its employees. Although the UJS has 545 employees, it is not one entity, but rather 545 individuals who are dedicated to getting the job done. While time does not permit me to recognize all of those who excel in our system, I would like to recognize two who have made exceptional contributions to our judicial system and the state. Justice Richard W. Sabers retired this month. He served on the South Dakota Supreme Court for over 22 years. Since the creation of the unified judicial system in 1975, this is the longest tenure on the history of the court. He participated in all the momentous legal questions of his age in South Dakota. His legal scholarship is found in literally hundreds of opinions he authored and many more in which he participated. He also provided leadership in the advancement of numerous administrative functions within the UJS. The justices set the operational policy for the UJS, and he spent the time and effort to make sure the policy was implemented in the best possible manner. He is here today, so we are honored by his presence. Please join me in honoring him. tough job requiring tough decisions. Yet from the top to the bottom of the UJS and throughout state government, DJ was admired for the way he undertook his task. He never forgot that while the UJS has its headquarters in this state capital, we also have 64 county courthouses. He was never happier than when he was visiting our employees in those urban and rural courthouses. This also gave him a unique perspective on how to administer the UJS. The justices appointed Patricia Dugan, former circuit administrator of the 3rd Judicial Circuit, to replace DJ Hanson as state court administrator. Like DJ, Ms. Dugan is a people-oriented person who you will get to know and like. We are confident that she will serve in the new position with distinction. Today, if you want to travel virtually anywhere, you can simply dial up a detailed map on the internet and it will tell you how to get there. One cannot say the same for the future. While we have general guides, such as our Constitution, statutes, experiences, and common sense, they do not provide a detailed guide which guarantees success. I'm reminded of Kierkegaard's admonition, life can only be understood backwards, but it must be lived forward. A lot has happened in the South Dakota Judiciary since 1975. It is so easy to look at our accomplishments and be well satisfied with where we are and what we have. However, an attitude like this is perfect embalming fluid for the future. We must move forward to meet the judicial needs of the citizens of this state. In 1975, the UJS began its mission with 37 circuit judges. 34 years later, we attempt to deal with the current society's needs with only 39 circuit judges, or 2 more than we started with. Of our 7 judicial circuits, 5 have the needed number of judges to timely do the job. The same cannot be said, however, for the 2nd Judicial Circuit, which serves Minnehaha County and Lincoln County, and the 7th Judicial Circuit, which serves Pennington County and the southern Black Hills. Our statistics tell us that the 2nd Circuit and the 7th Circuit need several additional judges, each to be fully staffed. The presiding circuit judges of both circuits say while the need for judges is immediate and great, that under current economic circumstances, they can make do for the foreseeable future that each circuit is granted 1 additional circuit judge. I will be asking this legislature to consider this request. Those of you who represent these areas, and those of you who rarely visit them, are aware of the population explosions and other social dynamics that have taken place and will continue into the future. Fields which existed there 20 years ago and produced only crops and no litigation or crime have given way to people who do. The UJS is fully aware that the ability of our citizens to fund state government is not endless. After the governor in October shared with me the significant financial problems the state government is now facing, the justices withdrew their request for 6 new probation officers, a probation officer secretary, a deputy clerk court, and a drug court program in the Pier area, despite the fact that they are needed now. This was not easy to do, considering the number of juveniles on probation in South Dakota last year increased by 15%, and all probationers increased by 6%, significantly higher than the national average of only 1.8%. The only item that survives of our original request is a request for 2 new judges and a support staff, which we concluded were essential for continuing successful and timely operation of our judicial system for the benefit of our citizens. South Dakotans have never been much enamored with self-pity. When problems arose, we simply got together to do our best to address and overcome them. Last year, this wonderful old Capitol building turned 100 years old. Obviously, those who planned it and built it with horses and block and tackle had a great faith in our long-term future. They had full confidence that those of us who were to come after them would follow in their footsteps and work for a better state for all. At the laying of the cornerstone in 1908, General Beadle declared, "The future of South Dakota is in its own hands. With the laying of this cornerstone, we introduce a new age. The test is upon us. We must make good." In the same vein, 100 years later, it's our ongoing duty not to disappoint. It's not been my purpose today to dredge up heaps of past and present problems. However, I'm a firm believer in Sandiana's classic observation observation that those who ignore the lessons of history are doomed to repeat them. Yet, I'm by nature an optimist. Were this not the case, I would have long ago found something else to do with my time other than undertake the duties of Chief Justice. As President John F. Kennedy noted in his inaugural address, with a good conscience our only sure reward, with history the final judge of our deeds, let us go forth to lead the land we love, asking his blessing and his help, but knowing that here on earth, God's work must truly be our own. South Dakota has been known as the Sunshine State. Our flag, right here, features the state seal surrounded by a golden blazing sun and fields of sky blue. In reality, the sun is not stationary. It rises and it sets. To me, that sun is rising on South Dakota, not setting. I firmly believe the best is yet